She will probably use that mic, so we'll stand back as she does her thing. 9, right? Yeah, John 9. As soon as she ready, Dex? Sure. Testing. I'm very happy to introduce Chief Judge Laura Lewis. She's the Chief Judge of the 16th Judicial District, and I wanted to allow her to give you a formal welcome.
Well, thank you. Good evening and welcome to everyone to Dodge City High School. As stated, my name is Judge Lewis, and I'm the Chief Judge of the 16th Judicial District. It's my honor tonight to welcome the Supreme Court of the state of Kansas here to Dodge City for the traveling docket. For those of you who are unfamiliar with our court system, the Supreme Court is the highest court, state court that we have in Kansas. It consists of 7 justices, including Chief Judge Marla Lukert, Justice Eric Rosen, Justice Dan Biles, Justice Caleb Stegall, Justice Evelyn Wilson, Justice Keenan Wall, and Justice Melissa Standridge. The Supreme Court sits primarily in their Kansas Judicial Center in Topeka, but does hold traveling dockets such as this one on a regular basis as a means to conduct outreach to the rest of Kansas and in order to provide more people an opportunity to witness the judicial process in action. This is the first time that we've ever had them sitting here in Dodge City, so it is an honor for us to have them here tonight. The Supreme Court is the highest of 2 appellate courts that we have in Kansas. The other appellate court is the Court of Appeals, and the Kansas Supreme Court is also known as the State Court of Last Resort. This means that the Supreme Court hears direct appeals from district courts in the most serious criminal cases and appeals in cases where a statute has been held unconstitutional. It may also review decisions of the Court of Appeals, transfer cases from the Court of Appeals directly to the Supreme Court, and has jurisdiction over certain original actions. As an appellate court, the Supreme Court reviews the decisions or judgments from lower courts to ensure that the law has been followed. The Supreme Court does not preside over trials. That means that the hearings before it do not involve witnesses, juries, new evidence, or court reporters. Instead, the Supreme Court reviews the written record of the trial court that consists of evidence admitted at the trial, including transcripts of witness testimony and rulings from the trial court to determine if any significant legal errors occurred during that process. Appellate procedure requires the parties provide the court with written briefs, which contain the parties' arguments and lay out each side's summary of the facts of the case, legal arguments, and legal authority that they are relying on to support their position. Sometimes, as part of the appellate process, the Supreme Court may hear oral arguments from the attorneys representing the parties in an effort to assist the court in deciding the case. This evening, you will be hearing such oral arguments in both a civil case and a criminal case. The civil case originated from a trial court in Finney County, while the criminal case originated from a trial court in Geary County. The trial courts in Kansas are also known as district courts. As I stated earlier, I'm the Chief Judge of the 16th Judicial District. The 16th Judicial District is composed of 6 counties. Those counties are Ford, Gray, Meade, Clark, Comanche, and Kiowa counties. There's a district court located in each one of those counties, including the courthouse here in Dodge City. There are 8 judges in the 16th District. 3 of those judges, including myself, are district judges, and the other 2 are Judge Sidney Thomas and Judge Andrew Stein. We also have 5 district magistrate judges that sit in each of the outlying counties, and those judges include Judge Keith Whitney, Judge Philip Moore, Judge Rustin Martin, Judge Richard McVeigh, and Judge Anthony Byer. Each of those district magistrate judges also fill in 1 day a week here in Dodge City for us. The 3 district judges, in addition to our duties here in Ford County, travel the circuit to all of the outlying counties at least once a month and as needed. As stated earlier, the district courts as trial courts are also known as courts of general original jurisdiction over all criminal and civil cases. As such, we do stay very busy in all the courts here in our district. And on behalf of myself and my colleagues, I would like to invite each and every one of you to come down to any of our courthouses and view some of the proceedings that go on there on a daily basis. I have no doubt that you will be surprised, maybe somewhat dismayed about what you learn about your community, its needs and the concerns by observing some of the court proceedings that we deal with on a daily basis. And I heartily encourage everyone to come on down on any day on one of our regular court days and attend a hearing. Finally, on behalf of myself, my colleagues, the staff, and the bar of the 16th Judicial District, I would like to thank the Supreme Court for choosing Dodge City to host this travel docket. We are proud to have them in southwestern Kansas. On a personal note, while I have had a few occasions throughout my almost 20 years in the practice of law to appear and argue before the Court of Appeals, I have never personally had the opportunity to argue in front of the Supreme Court or even to view a live session. So just like many of you here tonight, I look forward to getting to observe the court in action. Now, without further ado, I will turn the proceedings over to the Honorable Justices of the Kansas Supreme Court, and may it please the court. Your Honors, the floor is yours.
All rise. The Honorable Justice of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting.
Please be seated. Problem with computers is they go to sleep. Good evening. I am Chief Justice Marla Lukert, and it's my great pleasure to welcome you to this special session of the Kansas Supreme Court. We are excited to be in Dodge City and to provide you the opportunity to watch your Kansas Supreme Court in action, if you will, and also to meet with us and meet the justices during the reception that will follow the oral arguments. In an effort to make the Supreme Court more accessible to Kansans, we have turned to the Beach Boys to provide our Supreme Court on the Road theme song of "Round, Round, We Get Around." A couple of times a year, we leave Topeka and we visit a Kansas community to show Kansans how our court works. All of our hearings are public, but few Kansans can take time from work or school or their daily routines and the demands of their life to come to Topeka and to hear or watch a hearing. We do have live streaming of all of our hearings, so you can watch us at any time on our YouTube channel, but it's just not quite the same as seeing the court actually in session and and to be present in the room. So we are getting around, and we have been doing this for several years, and it really have found that it to be great opportunity for us to interact with our fellow Kansans. We have spent the day visiting area schools with the local judges. We appreciate the schools that have allowed their students to come and visit with us in those settings, and also for all the students that are here tonight. We thank you for giving us that time during the school day as well. Again, for all of you, we thank all of you for attending this evening. The students that we visited with attend Dodge City Communities College, Dodge City High School, Kiowa. We were in Greensburg, Meade High School, South Central High School in Coldwater, South Gray County High School in Montezuma. So you can tell we've put a few miles on the today earlier as we did that. We also met with our local attorneys from this area at lunch today. And we welcome the members of the bar who have joined us this evening. As I've indicated, tonight you have a chance to see firsthand who we are, what we do, and how we do it. We're delighted that you've taken time to learn more about how your Kansas court works. Tonight, as we will see actual court cases and actual proceedings in 2 appeals. As you know, public Supreme Court proceedings are called oral arguments, and attorneys will present the legal issues in support of their clients' positions. The attorney on one party will argue first, the other side will then respond, and then the first party gets the last word. Justices will ask questions to learn why why the attorneys believe the law supports their client's position. The interaction helps us meet our duty to enforce the rule of law and to make decisions that the law requires. The parties have presented written briefs to us, and they've cited the laws that support their position. This might be the U.S. Constitution, the Kansas Constitution, Kansas statutes, or our own court decisions. The law will form the basis of our decisions in these appeals. We don't evaluate whether the law is good policy. That is the job of the legislature. Our obligation is to set aside our personal beliefs, politics, special interests, and even public opinion. That means, for example, that tonight we will not conduct a public opinion survey or ask you to tell us how you think we should decide the cases that you'll hear with us tonight. We have to remove ourselves from all of those influences because our job is to remain fair and impartial courts for all Kansans. As Thomas Jefferson said about 200 years ago, the most sacred of the duties of government is to do equal and impartial justice to all its citizens. And we're very honored to be able to have the role in doing that. We hope you leave this evening with a better understanding of the contributions of lawyers and judges in furthering the rule of law and about the role of fair and impartial courts in our country. I would now like to introduce my colleagues. We come from all over the state in terms of our hometowns. I will mention that I grew up in the far northwest corner of the state in Goodland. Eric Rosen hails from Topeka. Dan Biles, to my left, your right, I guess on your right, grew up in El Dorado. Caleb Stiegel in Lawrence. Evelyn Wilson in Smith Center. KJ Wall, this direction in Scott City. And on this end, Melissa Standridge in Lawrence. Before the clerk calls our docket, I do want to express my gratitude to all of those who made our trip to Dodge City possible. I'll begin with the judges of the 16th Judicial Division. Kansas is divided into a judicial district, Kansas is divided into 31 judicial districts, and a judge resides in every county, all 105 counties, at least one judge. The 16th Judicial District, as you may know, consists of Clark, Comanche, Ford, Gray, Kiowa, and Meade counties. And the judges from those counties have helped us today in our school visits. I'd like special thanks to Chief Judge Laura Lewis and all of those local judges. A special thanks to Chief Clerk Rhonda Whitney and all of the clerks of the of the district courts in each of those counties as well. And I also want to thank our staff and the clerk of the Kansas Appellate Court and his staff and the Office of Judicial Administration who oversee the logistics of this evening and this entire trip. This activity takes a tremendous amount of planning and effort to ensure a successful event for you. Another group that has helped us a great deal with these activities are the law enforcement officers that you see around in this room and around the building, and our own security personnel who have assisted in planning and providing security during this trip. So a special thank you to the Dodge City Police Department, the Ford County Sheriff's Department, the Dodge City Community College Security Team, and the Kansas Highway Patrol. Finally, I want to give a special thank you to our honorary bailiff for tonight's docket. Our honorary bailiff tonight is Chief Court Service Officer Dan Fanninstill. Chief Judge Lewis nominated Mr. Fanninstill to serve as our bailiff tonight, and we felt very honored and fortunate to be able to have him join us in this capacity today. He has worked for the 16th Judicial District for 35 years, and since 1997 has served as the Chief Court Service Officers for your district. In nominating him for this honor tonight, or we think it's an honor, I hope he does, Chief Judge Lewis said, Dan is known throughout the district for his integrity, honesty, and sincere desire to make the judicial system as positive and efficient as possible. He is quick to offer support in whatever capacity needed and has been successful in maintaining a solid team of court service officers, even when the system overall has seen a lot of turnover. Can we all join in applause and thanking him for his service? With that, I will turn to the clerk of the Kansas Appellate Court, Mr. Doug Shima, and ask him to please call this evening's docket.
Thank you, Your Honor. May it please the court. Counsel will approach the lectern. The first case on the 6:30 p.m. docket for Tuesday, November 14th, 2023 is appeal number 124998, American Warrior, Inc. and Brian F. Price versus the Board of County Commissioners of Finney County, Kansas, and Huber Sand, Inc., Finney County. Counsel will enter their appearance.
May it please the court, Linda J. Lobemeyer appearing on behalf of the Finney County Commission, present and ready for argument. Also present with me is Mr. Shane Ludke on behalf of Huber Sand.
May it please the court, Patrick Edwards of Stinson LLP on behalf of American Warrior and Brian Price, present and ready for argument.
May it please the court, Ben Jackson of Jackson Legal Group of Scott City, Kansas, here on behalf of American Warrior, Inc. and Brian Price, and joining us is Jacob Price, General Counsel of American Warrior, Inc., present and ready to argue. Thank you.
Second case is appeal number 124607, State of Kansas versus Miles Martin, Geary County. Counsel will enter their appearance.
May it please the court, Patrick Dunn, Deputy Appellate Defender, and I'm here today representing Miles Martin, and we are present and ready for argument.
May it please the court, the state appears by Deputy Solicitor General Chris Elsleger, President and ready for argument.
Your Honor, that concludes our November 14th, 2023 docket.
Thank you, Mr. Shima. Counsel in the first case take their seats, and as they do that, I'll just mention a couple of more matters, a couple of explanations. I do want to explain to the audience that the justices are familiar with the facts of the case and the parties' arguments. We may at times take notes and look at our computers to consult our notes that we have taken before. We may look at something in a brief, check a case or a statute, or look at other items that the parties have supplied to us or that are a part of the proceedings in the courts that the district court and the Court of Appeals that considered this case before us. We do that to understand, to assist in our understanding and the processing of the arguments that the attorneys are making. We want to assure you that when we do that, when we are looking at our computers, we are still listening, we're still very engaged. And, but it does help us to sometimes to look at these things. So I will now call the case of 124998, and counsel may approach the lectern.
May it please the court, Linda J. Lobmeyer on behalf of the Finney County Commission. I'd like to reserve 3 minutes of rebuttal.
3 minutes is reserved.
Thank you. Justices, thank you again for traveling to our Southwest Kansas neck of the woods. This case boils down to the Kansas Court of Appeals. We applied for cert based on their ruling. In that case, they found themselves duty bound by what the Finney County Commission would characterize as dicta. That dicta has repeated itself throughout a string of case law, and that dicta goes back to a case called Crumbacker. When you go back to that case, there are multiple ways to distinguish the case. First of all, that case in particular determined whether or not a municipality can bypass zoning procedures through an annexation agreement. Of course, this court ruled that it could not. And in that case, they went on to say and make the statement that the power to change the zoning of property, which includes issuing special use permits, can only be exercised in conformity with the statute. We're not asking this court to overturn that principle. Obviously, it's our contention that the Finney County zoning ordinances comply with the statute. This case never addresses specifically 12-755. I think that particular statute is particularly important in this court's analysis. In that statute, it gives the municipalities, including counties, the authority to come up with a framework or a procedure for issuing conditional use permits. And I don't think any of the case law in my reading of it has never actually addressed this issue at hand. And the specific,
Before we get into the statutes and the case law, can you address the order that we sent out a few weeks ago asking whether this case is moot? Because, whether the permit is valid?
I was unaware of that. I did not see that.
Well, okay. I don't know what happened, but is the 2021 permit still valid under these regulations? Because as I read the regulations, it says that permits must expire after 1 year.
Right. No. Okay. I didn't receive that request, but I would say it isn't moot. Those conditional use permits, as long as it goes into continuous use, and as long as the sand in this particular case, the sand quarry has started its work, it stays in place. I guess that's probably at least something that may be addressed. However, this issue is going to repeat itself if the court doesn't make a ruling today or in the future with regard to this issue, because Finney County still has the same zoning regulations. It still has the same procedure for issuing conditional use permits that hasn't been revoked at this time.
Well, what draws our attention to it, and I'm sorry you don't have this, but a lot of things have gone awry in the last couple of weeks, but I want to draw your attention, I'm sure you've got it over there, to zoning regulation section 28.080. And what it says is, all conditional use permits shall be valid for 1 year from the date it was approved by the Board of Zoning Appeals if the project has not been substantially completed within 1 year of approval. The conditional use permit shall expire.
All right.
And to me, I read that and that tells me that these permits have 1 year.
Right. But in this instance and in several instances, they're going to be able to renew that so long as the sand quarry is still active and they haven't finished doing their quarry of that sand area. So yes, technically it could expire. Technically, they will need to go back to the neighborhood zoning and development and reapply or they may continue to need to renew that permit. But often, I mean, honestly, often in conditional use permits, those projects aren't necessarily finished as the zoning regulations refer to. They're often not finished within a year, and that's not uncommon for that to happen in that way.
And are you suggesting then that those parties do not come back and have a renewal process?
They do have a renewal process.
And
Yes.
What happened with this 2021 permit?
With this 21-1, I don't have that knowledge. I apologize. I apologize. I didn't get the note regarding the question of its mootness, so. Nevertheless, I'll return back to Krumbacher.
Let me ask you about
Yeah.
Krumbacher.
Sure.
You said that, you know, there's that sentence in there that everybody's animated about, making a reference to conditional use permits, but here's my operating theory. You say it's dicta. I'm not sure I agree with that for this reason. In Krumbacher, what the city of DeSoto did not only was contrary to the county zoning and all that, that's why they were going through the process. But what they were trying to do actually violated their own regulations, is the way I read that decision. It's a little subtle. But because of that, what the county, or what the city was trying to do was completely contrary to all the procedures that had occurred prior to that. So the idea that they could circumvent it through this annexation agreement is a little odd to begin with. Plus those, if I read the case, those regulations that the city adopted required you to go back to the planning board, and that in contrast, Finney County doesn't have that. Everything Finney County did is absolutely within the provisions of the regulations. And as I also read it, within the provisions of the statute. It's not until you try to bootleg in Krumbacher and that Manley case that the words start to morph.
Right.
At least in the view of the Court of Appeals.
Right. And actually, Justice Biles, I think that is a very good point in this situation, because I think you can also read Krumbacher and what it says as not being dicta, but very specific to the situation that they're talking about here. And you're right, the heft that particular statement was given was added on to as the case law goes on. And in the unpublished opinions that are cited, they just keep elevating those words and saying, we have long held that conditional use permits or special use permits are a zoning change. They inflate the actual meaning in there, which is never in statutes. 12757 never mentions conditional use permits, despite the fact that the phrase was used in 755 or in 12755, and despite the fact that, as the dissenting opinion from the appellate court points out, Chapter 19 regulating counties has a statute that does require the urban counties to follow 757. And I think that's also an extremely important point here, is that the legislature has required it of certain counties by statute. That requirement by statute is not placed upon all counties. It's placed upon the urban counties, being Sedgwick and Johnson County. And so I wonder, and I wonder whether or not some of the cases, and especially Krumbacher and Manley, both originating out of Johnson County, in actuality, 757 does apply to their conditional use of permits. It does apply to their special use permits and the requirements. But the legislature and the statutes under the zoning ordinances allow for for each of the individual municipalities, counties, to make their own zoning ordinances and to make their own rules regarding conditional use permits. I think it's also telling or that conditional use permits, special use permits are only defined in zoning ordinances for the localities. They're not defined by statute. And so it's a curious conclusion for the court to come to, that 757 would, and the procedure there would apply to a conditional use permit, given that there's no definition, standardized definition for what that is. I just think that's an illogical conclusion. If the county and the municipality are defining what it is, it seems to me that they should also have the authority and the ability, as the League of Municipalities pointed out, through home rule, they have the ability to make those rules for themselves, and in keeping with the spirit of the community, the nature of the zoning that's going on and the changes that are going on in their own locales.
Can I get a kind of a big picture here of what happens with a conditional use permit in Finney County and in other counties subject to the conditional permit allowances and the rules that counties set up for that? And that is, I'm just curious about the compatibility with what is already zoned. This particular parcel was zoned agricultural.
Correct.
And this conditional use was for a sand and gravel pit in operation. And it just seems so foreign to what the zoning is originally contemplated for, and the people that live around there, and and I understand it's your position that you followed your protocol of your county and that, but how much of, absent the exceptions that that conditional use permits are not permitted through statute, mining operations, this seems closer to like a mining operation to me than it does any kind of agricultural use. And is that a factor in any of this?
I think it's a factor in what the zoning regulations were and how they were designed. Obviously, the conditional use permit is allowed for the sand quarry under agricultural zoning, right? And you understand that. Maybe one of the specific geographic issues that the court should understand in Finney County and through much of Southwest Kansas, the Arkansas River runs through, and that's primarily where this is close to and where it's being quarried. Those lands abut a lot of agricultural lands, and that's where and why the zoning regulations allow it in an agricultural location. So for instance, Pierceville is probably geographically maybe even less than a mile maybe from where the river crosses, and primarily those sand quarries fall along that riverbed.
I have a question about regulation section 4.030, which refers to conditional uses. And it says the following uses and structures may be permitted. Number 6, state approved and sand and gravel quarries. I'm not sure what the "and" is there for. State approved and sand and gravel quarries. Is that an extra word? Are they supposed to be state approved sand and gravel quarries? And if so, was this one?
I would read that as including a both state approved and that would be how I would resolve that question, is that because any sand quarry has to be approved by the state. That's an automatic procedure that they have to go through the KDHE for, I think it's the KDHE that does that, and gives those permits for the sand quarry to continue. And so along the way on the procedure, you may have someone asking for a conditional use permit prior to actually getting their permit from the KDHE for the sand pit. And so maybe that's why that is. Of course, that's looking back at something that was drawn up in 1995. So I don't know, but that's how I would resolve that tension there. So I mean, if you thought about it as the sand company applying for a conditional use permit, they can apply for that conditional use permit prior to having the proper permits. but they will need to have the proper permits before they can actually exercise that conditional use.
I have one question coming back to my earlier question about, but I want to ask it just in terms of what's actually happening as far as you know. Is the sand and gravel operation currently operational?
My memory at this point is that they have not gone into Finney County. Part of that is that I think they, as we all are bound by the ruling from the Court of Appeals at this time. And I believe probably counsel for Huber Sand has advised them not to do that. However, it abuts Gray County, this piece of land also. So I know that the sand quarry in Gray County, which is directly next to it, has already started and is in operation.
But in Finney County, there is no operation. It's not started.
No, but the road is out there. The quarry equipment is out there due to it being in Gray County.
Permit beyond the 2021 permit.
I'm sorry, I couldn't hear you.
No permit past the 2021 permit that we are currently discussing.
I don't have enough information to answer that question. I'm sorry.
During your time before you come back for rebuttal, why don't you take a glancing look at 28.080 in your regulations. Let me know whether you think that permit can live past 1 year.
Okay, I will do that. Thank you.
May it please the court, Patrick Edwards on behalf of American Warrior and Brian Price. I'd like to start off by addressing a few of the questions that came up just a second ago. And the first is with respect to the court's question about whether the CUP in this case has expired for failing to substantially complete the project. The CUP was for a sand and gravel quarry. And I think it's important to know there are two tracks at issue here. One is in Finney County, directly next to Pierceville. And it's literally directly next to Pierceville. And then that track directly abuts the county line to Gray County. And then right next to there's a Gray County parcel. The CUP in Gray County followed the correct two-part process from 757 and was granted. And so the sand and gravel operations currently, the actual mining is going on in Gray County. And to our understanding, there's been no sand or gravel mined in Finney County. There is a road that's been constructed on the Finney County tract. There's a portable office that's been placed on the Finney County tract, and they've stored some machinery and equipment on the Finney County tract. But there's been no actual mining on Finney County. The other thing is the CUP, part of the conditions that the BZA imposed was that a fence with barbed wire be built on the outside of the tract in Finney County, and that there be trees planted as well. It's our understanding that there was, for a year and a day after this permit was issued, there was no fence that was constructed, no trees that were planted. And in fact, it's our understanding that just recently, within the last few months, there was a fence that was started to be built. But as part of the construction process, there was a line that was hit that ran into one of the neighbors' houses in Pierceville, a gas line. And so they stopped construction. So it's my understanding, at least, that to this day, the fence has not been completed. No trees have been planted. No sand or gravel has been mined. So it's our position that the permit has expired for failure to substantially complete the project as the zoning regulations state.
But counsel, that strikes me as a factual question that may not be before us. I think my question, and maybe some of the questions I'm hearing from the other justices, is whether the permit has expired by operation of law because its term lasts only for 1 year. So could they begin a gravel operation tomorrow without returning for a new permit or approval.
It's our position that they need to go and apply for a brand new permit at this point.
Council, can I, while you're answering Justice Wall's question, can I ask just a basic housekeeping? Did you guys get a copy of this order from us to be prepared for the mootness?
Yes, I did. Your Honor.
Okay, so at least somebody got it. Great.
So
I have a quick-
following up on, oh, I'm sorry. Go ahead.
My question is pretty quick. Why is what happened in Gray County even relevant here?
Just that there's, I don't think it is, to be honest with you. I think the
Right.
issue is Finney
Thank
County.
you.
So to follow up, based on your argument that as a matter of law, this permit expired, why wouldn't this case then be moot?
We believe it is moot. We believe the petition for review is moot.
Okay, so you are taking a position that this is a moot case and we no longer have jurisdiction to hear it.
We're taking that position, but because we would like some finality on this, at the same time, if the court were so inclined to issue an opinion on the merits, we would invite that.
Well, so let me ask one more follow-up. So our mootness doctrines do speak about exceptions for cases of high public importance that are subject to repeatability. And I guess my question is this one of those circumstances? And I guess the worry would be if these permits expire as a matter of law after 1 year, the issues may never get to a court.
So
Do you see that? Does that make sense as a question?
I think so. It's unclear to us as to whether or not this can be subject to repetition. And the reason is because if this matter goes back to Finney County and the Court of Appeals ruling is enforced, that would require this process to go, or the CUP to go before the Planning Commission, which it's never gone before, for a recommendation, and then go to the County Commission for a final vote, including before one of the county commissioners that represents Pierceville. And so we don't know, as a practical matter, given that it's going to before completely different bodies, including an elected body that time, whether the outcome is going to be the same. The CUP very well can be denied the second go around.
Let me follow up with that because you conditioned that on embracing the rationale of the Court of Appeals. But if my math is right and my reading of the Finney County regulations is correct, the permit expired on July 20th, 2022. The Court of Appeals didn't issue its decision until February 10th of 2023. And under our case law, the Court of Appeals opinion goes away because it didn't have jurisdiction because the case was moot, unless one of the exceptions then would apply. So let me give you the hypothetical that if the Court of Appeals decision goes away too, does your answer change to Justice Stiegel's question about whether this is subject to repetition?
It very well could be. And again, that's why we would, in that instance, we would ask for a decision on the merits. Yes.
Would it be subject to repetition if a party who knew they had an expiring conditional use permit simply took the additional step of asking for it to be renewed? And that seems to me to be the root problem of all this mootness discussion is just why wasn't the conditional use permit renewed?
So I'm sorry, I could not hear that.
Why wasn't the conditional use permit renewed?
We don't have the conditional use permit. I think that would be a question for Huber Sand.
In your,
If we're,
in your opening kind of statement to us, you referred to this as a mining operation. Did you seek that kind? There's an exception that requires an additional step to be taken in the conditional use permit statutes that specify that mining operations are different and distinct from sand and gravel operations and other types of conditional use permits. Did Did you seek to utilize that exception, or did the court ever deal with that? I couldn't find that the court ever took that question up.
The court didn't take that question up, but I will tell you that KSA 12-757 a, so not subsection A, but little a, is the statute immediately following 757. And in that statute, it requires a majority. It essentially says that for a mining operation, it's got to be a majority vote of the governing body. Sand and gravel quarry is a mining operation, and there was no vote by a governing body in this instance. The CUP went before the BZA and only the BZA. The governing body in Finney County is the county commission, and this CUP never went before the governing body, so there was never a vote at all by the governing body, and so we believe that it does fail under 757 little a.
So let me ask you, just so I can understand, because you're the expert in this area, so I'm going to tap in to your knowledge. So the difference explain to me the difference between an amendment to a zoning regulation or a zoning code, so I guess a rezoning, and a special use or conditional use permit.
So a special use or conditional use permit, and those terms are used interchangeably,
Right,
essentially, allow for land to be put towards an otherwise prohibited use. And essentially that use is not allowed unless a CUP is issued and conditions that are imposed as part of that CUP are followed. A zoning amendment can be a number of things, just amending the zoning regulation, whatever. But I will point out that the Court of Appeals majority opinion in this case went through the analysis and essentially found, based analyzing Crumbaker and also referencing Manley, that that a CUP is the functional equivalent of a rezoning, and that the Manley case, inherent in the ruling in the Manley case, was that I guess an SUP in that case was a zoning amendment. And so they are different functionally, but the court has analyzed this and said that they're the functional equivalent, that a CUP is the functional equivalent of a rezoning or zoning amendment, so it falls under the statute.
Okay, so let me ask you this. When you were talking about a special use permit or a conditional use permit, you said something about unauthorized. Is that what you said?
An otherwise prohibited use.
Right. Well, then what's a variance?
So a variance is a request to deviate from the zoning regulations. A lot of times a variance is, for example, a height limitation in a particular zoning district. If you can not have, any building beyond, above 3 stories, well, you can get a variance to deviate.
What's the difference then between a special use or conditional use permit and a variance? Because they're both, you're saying they're both kind of unauthorized or violations, because it's my understanding. Okay, and I don't want to really talk about the past case law and extracting that sentence.
I would love if we could avoid that.
Right, let's just, because we're just looking at the statutory language, okay? So it's my understanding that a special use of a CUP, is that a CUP is a use that is already conditionally authorized under the current zoning regulations, but a specific criteria that's already set forth in the zoning regulations have to be met. And meeting those, you have to have the approval of whoever the approval committee is that's designated. And it doesn't change or amend the regulation, because the regulation says you can do this, but you got to do a few more things.
Yeah, and I think the dissenting opinion kind of in the Kansas Court of Appeals hit on this, but the difference is, in our opinion, that in the majority opinion touched on this as well, is that CUPs aren't automatically granted. In fact, they're denied all the time.
Right.
And in a CUP, essentially in zoning ordinances, there's a list of uses that might be possible. So there's
Contemplated.
Yes. Yes,
Contemplated.
but just because it's contemplated does not mean it's automatic. Far from it. And that
but do you have to amend the regulation?
We believe the position of the case law in Kansas is that it is considered a zoning amendment. It is considered a rezoning.
And what are you relying on for that?
Crumbaker, Manley.
No, I don't want you to rely on those. What else are you relying on? Or is that all you have? to
Well,
rely
the
on?
definition of zoning is under Kansas statute
Yeah.
is that the regulation or restriction of uses of land. And certainly a CUP is a regulation or restriction on the uses of land, and you cannot have a use, like, for example, sand and gravel quarry. Without a CUP, it is a prohibited use in that zoning district. You cannot have it. And so you have to go through the process of applying for a CUP. The jurisdiction has to go through.
Why do we have conditional use permits then if it's the same thing as rezoning or an amendment?
I don't think it's always the same. I think there are differences where a CUP is considered a rezoning, but a rezoning is not always considered a CUP.
Wait, slow that down and say it again.
Every CUP is, as the court has analyzed, is considered a rezoning. You can have a rezoning that is not a CUP. You can
Right.
rezone property and have it not be a CUP.
Right, but if every CUP is a rezoning, why do we have CUPs?
That's the way that the jurisdictions have decided to handle certain conditional uses that are otherwise prohibited without the going through those additional steps.
I want to take you back to the mining statement that you made. These were competing motions for summary judgment, correct?
Yes.
It's my understanding that one of those uncontroverted facts was that in May of 2021, Huber submitted an application for a conditional use permit, or CUP, to the Board of Zoning Appeals, seeking approval from the board to operate a sand and gravel quarry on the property as an approved conditional use under the regulation. It's my understanding that was a fact to which both parties agreed. Is that wrong?
That they submitted a CUP to the BZA?
For a sand and gravel quarry.
Yes, that's correct.
You agree?
Yes. I'm running out of time here. One additional point I'd like to make is the reference to Crumbaker being dicta, and that, well, the facts in Crumbaker were that the zoning regulations applied they had zoning regulations that applied the two-part process. That's a red herring, because whether or not well, first of all, they applied KSA 12-757 to the zoning regulations and to the facts at issue in that case. And if all that mattered was what the zoning regulations say, because that's essentially the point, is, well, the zoning regulations there match the statute. If all that matters is the zoning regulations, then there would be no reason to analyze the statute whatsoever. You could just go off the local zoning regulations. But that's not what any of these courts have done. The three cases before this court and the Kansas Supreme Court, and the 5 cases that we've cited in our brief from the Kansas Court of Appeals, each one of them has analyzed the statute in different parts of the statute, certainly, but they've always consistently applied KSA 12-757 to CUPs and SUPs. And the public have relied on those decisions, including American Warrior and Brian Price. And so we just ask that the majority ruling from the Kansas Court of Appeals be affirmed, and based on the arguments asserted here today and also in the briefs. And I'd be happy to answer any additional questions you have.
See no questions. Thank you. Slowmeyer, you reserve 3 minutes.
Justice Biles, I'll start by answering your question, and I think you're correct in your reading of the zoning regulations for Finney County that it would have expired. The reason whether or not this is moot is that this is repeatable. Every conditional use permit in the reading of the reading that the Court of Appeals gave to Crumbacher and its progeny, and what what American Warrior is advocating for creates a situation where every conditional use permit that has been issued since 1995 has failed to follow statute and is invalid. So this is hugely important. I think it's also evidenced by the amicus briefs that you received from the League of Municipalities and from the Finney County, or not the Finney, the Kansas County Association. There are a lot of counties and a lot of municipalities that are using similar framework based on the authority we believe was given to them in 12-755. I do want to also address, before I move on, 757A. This is not a mining operation as defined by Chapter 49. We disagree with that reading. That's Chapter 49 talks about surface mining, and that's a completely different operation than sand quarry. That's a different set of regulations and a different set of rules. And I think that's a misinterpretation of 757A to say that the sand quarry is a mining operation under that definition.
Counsel, would you agree that the potential mootness problem could have been avoided had the applicant simply asked for the permit to be renewed?
That is, yes.
So we wouldn't even need to talk about whether a prudential exception might apply if applicants who desire to see this issue litigated to the end took the trouble of getting a renewed permit.
Right, of course, but as I can't remember which of the justices pointed this out, the ruling came after the expiration date initially to begin with.
Well, why wouldn't a party, I mean, if they understand that their permit to do what they want to do is going to expire, why would they not?
Justice, in all candor, I am not 100% confident that they haven't reapplied. I don't know that for sure. I consulted with co-counsel regarding that. He was not aware that they did. That's a procedure that they can do without counsel and often do without attorneys. So I can't say with 100% confidence that they didn't. I don't think that they did. I think I would have heard if
But
they have.
as far as we know,
as far as we know,
hearkening back to Justice Wall's question, if they desired tomorrow to start the operations, they have no legal authority to do so, regardless of how this case comes out.
Sure. That would be correct.
Okay.
Yes.
Other questions? Thank you.
Thank you.
Thank you to both counsel for your arguments in this case. The court will take this appeal under advice. Thank you. I will now call case number 124607, State of Kansas versus Miles Martin.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Miles Martin. Madam Chief Justice, may I have 3 minutes for rebuttal?
3 minutes is granted. Thank you, Mr. Dunn.
Thank you. This appeal comes before the court following Mr. Martin's convictions for simple possession of methamphetamine and possession of methamphetamine with no tax stamps affixed. My plan tonight was to kind of flip the original orders of the issues as they were presented in the Court of Appeals and present them in the same order that was in the petition for review. To talk about the lesser included offense issue first. And if time and if the court, of course, as always, if the court directs, to talk about the suppression issue, time permitting, but anything we don't get to, I would go ahead and submit on the brief. And with that, I'd go ahead and move into the lesser included offense issue. I've been around long enough to have watched the evolution of this from the abolition of FIKE in 1998 through the recurrent recod. And basically in Kansas, lesser included offenses are covered under KSA, it's statutory, KSA 215109. And 215109A allows the prosecution of more than one crime based upon the same conduct. However, subsection B says if one of those crimes is a lesser included offense of the other, then only one conviction may result. And that's where we have the problem in this case. The remedy for this has always been that the court enters a verdict as to the greater offense and the lesser included offense effectively goes away. So what are lesser included offenses? And as I was one of the participants in Schoonover, I can tell you that we look at two specific places that are relevant to this case, subsections B1 and sections B2. And B1 doesn't at first glance apply to this case. B1 says a lesser included offense is a lesser degree of the same crime. And I'm going to come back to that in a second, but section B2 is when a crime where all of the elements of one of the crime are identical to some of the elements of another crime. And that comes into play here.
Don't you shortchange yourself on the way you just, I mean, don't we, let's go back to the exact wording of the statute, because that's where a crime where all elements of the lesser crime are identical. And to me, the lesser crime stands out as a separate term, which I think is your argument.
Well, if that were the case, then that would make subsection 1 somewhat redundant now. Because subsection 1 actually cares about the degree of the crime, which is an implication of the lower severity level of the crime. Subsection 2 is only concerned with the elements of the crime. That's all that matters.
Is that true if you consider that subsection B2 lesser crime to be still referring to a lesser degree, just not of the same crime as in 1, but as of a lesser degree of a crime with some of the elements?
I would say the plain language, my response is the plain language of the statute lacks the word degree. It lacks the word severity level. Nowhere is that present. The only word is lesser. And to me, it seems the most reasonable definite reason that it says lesser is because there are fewer elements. There are fewer elements in the lesser crime. The greater crime has more elements. It has all of the elements of the lesser plus some more. And that comes into this case for where we're going with this. This case should be exactly the same as Hensley. The twist, obviously, and that's where the Court of Appeals had a problem with this, was exactly what the court's pointing at, is this is a weird twist because the greater offense in this case is the tax stamp violation. All of the elements of possession of methamphetamine are contained within the elements of possession of methamphetamine with no tax stamp. There's no way to possess meth without a tax stamp without first possessing meth. So it's as simple as that. Now, the twist, of course, is that possession of methamphetamine with no tax stamp is punished less severely. One is on the drug grid, simple possession of meth, whereas the other is on the non-drug grid as a severity level 10 and has lower punishment. But it's our contention that that's irrelevant. Nowhere in subsection 2 is the punishment or the severity level of the crime.
So you're saying that the meaning of the lesser crime is the same as the meaning of any crime?
No. Lesser refers to the number of elements in the crime. There are fewer elements in the lesser crime. The greater crime has more elements. It has all of the elements of the lesser plus more.
Wouldn't that also be true if you said any crime? A crime where all elements of any crime are identical to some of the elements of the crime charged, because it's defining a lesser included crime.
I think that the problem I kind of have with that is that pushes us into another statutory subsection. I think it's subsection G, where we talk about identical offenses. There when you're talking about any.
No, they're not identical because one only has some of the elements of the other crime.
Yeah, okay. Taking that into account, if, as a fallback on this, if that is the case, then certainly we're talking back and forth about this. That certainly seems to imply there's some sort of ambiguity there. If it was plain, it would say a lesser degree or the word severity level would be in there. And if there is an ambiguity because this is a criminal statute, it has to be construed in favor of criminal defendants. So therefore, my interpretation should be the interpretation that prevails in this case. Undoubtedly, opposing counsel is going to follow along with the court's argument here. However, I still think as the plain language of the statute is what controls. When you talk about degrees, the legislature showed it knew how to discuss the degrees of crimes. It used the words a lesser degree of the same crime in the first one. It could have said a less severe crime, crime where all the elements of the less severe crime are identical to that. If it wanted to limit it only to the situation where it was a crime that had a lower severity level, but they didn't do that. That is our position.
Counsel, as much fun as it is talking about statutory interpretation, I do need to move you over to the suppression of the methamphetamine question. Here's my problem. You want us to take a snapshot of the evidence as it existed at the suppression hearing to decide whether the district court correctly decided the suppression issue, right?
I believe so.
My problem comes from the contemporaneous objection rule and the fact that in order to preserve the challenge, the objection to the evidence coming in to the jury required the defendant to make an objection at trial, which the defendant did. But the snapshot of the evidence that should occur at trial ought to include everything that's happened before that objection is made at trial, which would include a larger universe of facts than the snapshot you want to take at the hearing. I understand what you're trying to do. At that hearing, it looks like the state missed a couple steps in the process, and so did the district court. But it seems to me by the time you get to trial, and you take that a snapshot of the evidence available to the district court at trial, there's a larger universe and there is enough factual basis to overrule the objection. That makes sense?
Well, I think before we even get to that point, we have a problem of whose burden this was to begin with. Once the defendant raises a Fourth Amendment, Section 10, Kansas Constitution challenge, the burden shifts to the state to produce an exception. And what were those exceptions the state cited? The state never cited search incident to arrest.
I understand all of that. And I get that. I just don't understand why when the objection is renewed at trial, we can't take in everything that happened.
Right.
Prior to that objection being made. Regardless of who has the burden. You're right, states, let's give the state the burden on that. There's still enough facts to overrule the suppression objection at trial. And it's the objection at trial that matters.
I think, again, our position on that I'm trying to mention is that you can throw out all the facts in the world, but it's not the court's role to pick and choose from those facts what Fourth Amendment exception applies.
But
And
a
that's,
a Jackson v. Deno hearing, which is which is what this was, to determine whether there was, whether this evidence can be introduced at trial, is not even required before trial, is it?
this isn't a Jackson v. Denver hearing. That's a Fifth Amendment.
Oh, I'm sorry.
Sorry, I'm not.
But
This is a Fourth Amendment situation.
isn't this much like a motion in limine where you really, in order to if you introduce the evidence at trial inappropriately, it's going to be reversed. And here, if it was introduced appropriately, then all of the facts at trial, to Justice Biles' point, means that it is cured.
I guess I think we're talking past each other and I'm missing exactly because I'm not seeing, it's not a motion in limine.
No,
That's a different thing.
no.
We're still talking
but-
about a
Right,
suppression, a Fourth Amendment suppression situation, which is
right,
different than Fifth Amendment jurisprudence on this.
right. But the important thing is that the evidence at trial is legitimately presented.
Assuming if it's presented and cited in support of the ground that was provided and the district court rules on it that way.
Right.
So what mistake are you saying the district court made at trial when the objection was made by the defendants to suppress that evidence?
I don't think there was an adequate citation to the appropriate ground. And
Before you sit down,
perhaps I'm not, I was thinking it because that was something that hasn't been raised before. I hadn't thought about it completely, and I can, while opposing counsel's up, I can take a look.
before you sit down, why isn't this a consensual search? She handed over the pill bottle. She wasn't forced to hand it over. She gave it to him. Does that exception come into play here?
No.
Why not?
Well, the state's whole proposition is that he was in custody at the time and under arrest, and your whole element of consent ceases to apply in that situation. A reasonable person, once they've been detained by officers and they're told, give me, so what else do you have on you? Do you have anything? That is not a voluntary relinquishment of those items at that point in time. When a police officer tells you, what do you have on you? And, oh, is that it? Because it wasn't even the first time, it was the second time. And technically this if you want to call them all searches, you had an initial pat down by the other officer. Then, which should have taken care of all of this to begin with. But then you have another, oh, well, she was going to put him in her patrol car because he was warm. And then there was an element of this little dog involved somehow. But yeah, okay, well, what do you have on you? Here's my cell phone, my wallet. And I don't know if there's another item. Oh, is that it? And then, okay, here. Clearly, it wasn't do you mind? There was no saying no, is the short of it. And that happens, and I believe the case law supports, once you're in custody and under arrest.
I'm fine. Thank you.
Can I take you back to your multiplicity argument, counsel? If this court doesn't agree with your interpretation of the statute, do we still apply our traditional multiplicity analysis under Schoonover, or do we have to incorporate, how do those two things fit together? The Schoonover test and subsection B2 of the statute, if at all?
I think I'm not sure what to think. I think they dovetail exactly together. You look at the elements of one, are they fully contained in the other? It's severity level of the crime is irrelevant on this. I think the more interesting question comes to remedy, because the statute specifically says only one can go in. Now, my point on that is we should follow what the law has always been, and it's the greater that stays, which just so happens to benefit my client in this situation. And that's what we have always done. I went back to try and find if there was ever a situation like this typically you go back to these lesser degree things, it really goes back to homicides, specifically with felony murder and merger with that. But I was unable, and I went back quite a ways to find anything wherever they said, oh, the court can just arbitrarily choose whichever one he or she wants to keep in that situation. It has always been, and pick 6809, I think it is, says this is what you do. Granted, pick is not a court holding or the legislature, but it's just recognizing what this court's always done. And I think it's kind of odd, and it certainly is not particularly becoming to say, no, we just always want to give the hardest possible thing to the defendant in this situation, when you should follow the rule as it's always been. The greater offense is the one that remains, which again, in this case happens to be the less severe one. So.
No other questions? So thank you, Mr. Gunn.
May it please the court, Chris Elslager appearing on behalf of the state, making another of my recent string of relief pitching appearances, meaning I came into this case very late after all of the briefing had been done, the petition for review had been granted. So I have that kind of unsettling feeling of coming into the game with runners already on base. And so I hope that I can adequately answer your questions. So keeping with my analogy, we'll see if I can throw some strikes. Fundamentally, the statutory interpretation question, when you look at KSA 21-5109B2, it says, a lesser included offense is a crime where all of the elements of the lesser crime are identical to some of the elements of the crime charged. Well, what's critical here is the word lesser. Lesser means something, right? The legislature doesn't put in meaningless or superfluous words. So what does the word lesser mean? Well, just what the Court of Appeals said it gave it, ordinary words get their ordinary meaning, right? It says statutory construction.
Well, the dictionary definition, counsel, of lesser can mean fewer, or it can mean, I don't know how the ordinary dictionary definition of lesser clarifies it necessarily, because it could mean fewer, which supports your opposing counsel's argument, but it could also mean less severe too, which would get to your interpretation of the statute. So is it ambiguous? Do we have to resort elsewhere, or what is there additional language around the statute that clarifies?
Well, I mean, first, I'm just saying the common sense meaning would be the same meaning that the Court of Appeals applied to it, is the less severe crime. I mean, it's a bit strange to say lesser equates to number of elements, because there's lots of, crimes of varying degrees of severity have fewer or greater numbers of elements. I mean, murder is a rather simple crime when it comes to elements, although there's some crimes, some white collar crimes that might have multiple complex elements, and because I just heard his argument sitting here, I can't pull it off the top of my head, but I'm sure that there are many crimes out there that have more elements than the crime of murder, and no one would argue that murder is a lesser included offense of those crimes.
So if you look at subsection B1, it says lesser degree, and you look at subsection B2, and it says lesser crime. And your position is that under B2, lesser crime is severity level.
Yes.
Then what does lesser degree mean in one?
As we know, not all crimes have degrees. Only some crimes have degrees, and it's changed over time. But the one that obviously comes to mind is murder. You have first degree, second degree murder. And honestly, right now, as I say, I can't think of any others now that have degrees. I think historically some may have, but off the top of my head, I can't think of any. But that would refer to those crimes that clearly have defined degrees. And in the case where you don't have defined degrees, well, then you look to a lesser included offense is a less severe crime. It really,
So it's your position that B1 only applies to first and second degree murder?
Or any crime where it's defined in degrees. And just like I said, off the top of my head, I can't think of others. That one comes to mind. We could pull the statute book out and search for some, but I mean, there may be others. And it may be a vestige from the past too. There may have been, used to be other crimes with different degrees that have changed over time. But obviously murder still has degrees. So that part of the statute still has application to crimes of murder. The second section, the one that
if lesser crime in subsection B2 means severity level, then what does the reference to elements mean?
which reference to elements?
A crime where all elements of the lesser severity.
Well, that's for making that's so you can compare the crimes, because obviously it has to be it has to be included in the crime. So again, theft is not included in rape because the elements are completely different. That's talking about the substance of the crime, not the number of elements. I mean, you're really straining logic to equate it to the number of elements. I think the common sense approach is the less severe crime. And this isn't the first case where this has happened. There's another one, State v. Morones, is another Court of Appeals case from 2015, where again they said when determining whether a crime is a lesser crime, courts should look to the severity level of the crime, and that makes sense. And it makes sense here when the other aspect of this is when it comes to these lesser included offenses and the aspect of the double jeopardy clause. There's language in the case law that says you look to see if the legislature intended to basically make multiple punishments or multiple crimes. And here you have really two separate crimes. You have possession of the methamphetamine and you have the failure to pay the tax. Those are two separate crimes. Now, yes, they share some of the elements, but they don't share all of the elements.
But can you have one without that? Can you have the crime of not having a drug stamp without possession of meth?
No, surely you do have to have the possession of meth, but it's not a lesser than, because the legislature thought this through. They made possession of methamphetamine the more serious crime. It can't be a lesser crime of the less severe crime. That doesn't make any sense. That's why
if we're convinced by your argument, do we have to overturn Hensley?
No, because Hensley is distinguishable. And you can look at the way the Court of Appeals distinguished it here and the way the Morones court distinguished it. Because there, the possession of marijuana was less severe than possession with the tax stamp, or possession without the tax stamp. It was a felony without the tax stamp, but simple possession of marijuana was a misdemeanor. Here, it's flipped, which again is why I think the legislature did this intentionally, because the legislature intended to punish two separate things that are related, but two separate crimes: the possession of methamphetamine and the failure to pay the tax. Of course, the only way to prove the failure to pay the tax is to show the person has the methamphetamine and no tax stamp. But there's an extra element, the no tax stamp. So
you agree with the outcome in Hensley, but you say it's distinguishable because it was possession of marijuana, which is a misdemeanor.
Yeah, again, and it's the same argument. It's a severity level thing. The reason that Hensley is distinguishable is because the crime that had all of the elements that were included in the other crime was a lesser crime. It was less severe than the possession of marijuana without the tax stamp. Here, the possession of methamphetamine without the tax stamp is the less severe crime. So the more severe crime cannot be the lesser included because it's not lesser. I mean, I'm hinging on basic English. I mean, that is my argument, and I think it's really strained to suggest. I don't think I've seen any case anywhere where lesser included offense has been defined by the number of elements. Because obviously different crimes have the number of elements is just the number of substantive things that need to be proven. It has nothing to do with how severe a crime is.
Well, it's not merely number of elements, right?
I'm sorry, I can't hear you.
It's not merely number of elements. It's like the nesting doll phenomena where one is entirely included within another. And my question specifically is, doesn't the legislature's choice of these two words suggest that number of elements is important? They first talk about all elements, of the lesser, and then they refer to some elements of the greater, the crime charged. Doesn't
Right.
that force us to, just as a matter of sort of logic, conclude that one, the two crimes share elements A, B, C, and the greater crime has element D also?
But there's nothing in the statute that ties lesser to the elements. The elements just shows, as you said, which crimes are nested together. If they didn't have, if severity didn't matter, then the court could have done what my opposing counsel did when he got up here and started his argument. He said he left out the word lesser and just said the other crime, any crime. They could have used that word, but they used a specific term. They used lesser, meaning less severe crime. Now, to be an included crime, that's where you look at that's where the elements comes in. Is it included? Are those elements included in the other crime?
But
Lesser,
aren't those elements included here? Isn't possession included in the tax crime?
yes, but it's not lesser. You
Well,
have
let me-
lesser and included.
I understand you want to hang your hat on severity level, but back to the statute. If we skip over subsection 1 and just try to read the previous sentence in conjunction with subsection 2, it says a lesser included crime is a crime where all elements of the lesser crime, and I'll stop there. Do you think that lesser included crime is the same thing as lesser crime?
No, I think both terms mean something.
So you think,
Lesser and included.
is that
mean-
I guess my question is just, that doesn't strike me as a natural reading of that sentence would suggest that when the sentence starts, a lesser included crime is a crime where all elements of the lesser crime, that basically we can infer that that second phrase really is lesser included crime.
Yeah, I mean, I think it has to be both lesser and included. I mean, it can't be greater and included. A greater crime can't be included in the lesser crime. But you have to read the two terms together. Does it? Okay. Am I answering your question or am I lost?
Well, don't we also have to in reading those together, recognize that the only two places where lesser is used without the term lesser included is when the reference to a lesser degree in 1 and the reference to a lesser crime in 2, which can that be read to mean that the lesser in 1 is and the lesser in 2 are referencing the same terms, i.e. lesser degree of crimes or lesser severity level.
Yes, yeah, I think that, I mean, it does define them as lesser and include, it says a lesser included is, but then you're right, in the next subsections, it just talks about the lesser degree or the elements of the lesser crime are, then of course, they read back are included in the greater crime. But I think lesser means something, and I think you have to, I think, give it its ordinary meaning, which would be, just as the Court of Appeals found in this case and in the Morona's case, the less severe version of the crime. And if I beat that horse to death, then I will move on to the other issue. Are there any other questions on that one? All right, the search issue. I mean, first off, it seems to me from the state's point of view is almost, almost shut. I mean, there's plenty of case law that says that a search incident to arrest doesn't, it doesn't have to happen after the formal arrest. It's kind of putting form over substance in that case.
Counsel, I understand that's the exception. You're arguing that in this case, law enforcement did not need a warrant to search because the search was incident to arrest, meaning that those two things, the search and the arrest, happened in reasonably contemporaneous time. But the evidence to support that exception didn't come out at the suppression hearing. It really came out at trial. And federal courts, federal appellate courts look at the record in the entirety, including the trial evidence, when a suppression order is challenged. I don't know that our court has taken a position on that before. So first of all, do you agree with the evidentiary assessment I gave you? And if so, how do we approach the review of the evidence in an appeal like we have before us right now?
Okay, well, this is where me coming into this case so late is going to be a challenge for me. I guess from what I've heard here, I would fall back on the contemporaneous objection rule in that if, at the suppression hearing, if insufficient evidence was there to support it, but the court allowed it anyway, or said I'm going to allow it anyway, and then you get to trial, well, there then has to be a contemporaneous objection at trial at that point, because you never know. I mean, the state may decide not to try to introduce it or whatever. Once it's introduced at trial, there needs to be an objection at that point, and then the court can consider all the evidence in front of it to determine whether it's admissible, because we know whether it's a motion to suppress or a motion to eliminate or whatever.
Counsel, I'm just going to interrupt you very quickly, just because I think the facts let me just clarify what the facts were, that it did come out in the preliminary hearing. Okay, she did say that she put him under arrest right afterwards. Okay, so it came out in the preliminary hearing. Right before she was going to testify on the stand, counsel for the defendant said, I would like to renew my motion to suppress. Okay, so before she testified.
Okay.
And this was a different judge from the preliminary hearing and from the motion to suppress. And the judge looked at the papers and said, I'm going to deny it based on the ruling on the motion to suppress before. And so then she testified, I arrested him. She testified to facts that would support the requirement that the arrest followed shortly after the search. So in responding to Justice Wall's questions, at least that's how I understood the record contained the facts. So go ahead with that.
Okay. Well, again, I'm going to say that all of the evidence should matter, and ultimately, there is an old axiom of appellate practices that the district court can be affirmed for any reason. If it got to the right result, then it should be affirmed. And if there was a factual basis to support a search incident to arrest, then the district court got to the right conclusion, regardless of how it got there. And so I would ask that you affirm on that basis. But I said, unfortunately, I can't. I'm a bit at a loss to discuss the specific facts, because I came into this so late in the game that I had no. I'm not that familiar with the actual record of the preliminary hearing and the motion to suppress.
Thank you.
And if there are no further questions, that concludes my argument. Would ask the court to affirm the district court and the Court of Appeals. Thank you.
Thank you. Mr. Dunn, you reserve 3 minutes.
I sincerely hope I don't take that long. First, I guess the main reason I was going to get up, and apparently Justice Standard beat me to page 75 in the jury trial, which I had forgotten that the continuing objection happened just before her testimony. And I think my position would be that's when the snapshot is taken. Because how are we supposed to know what the district court considered, what went into it? If things that have, say something was mentioned in a motion for a new trial later, certainly that wouldn't be something we would consider. I think.
But why would we suppress evidence when there is evidence in the record that arguably at least would support the search as lawful? Let's just say hypothetically, just based on the timing of the objection.
I guess that's, I don't know that you really want to get me started on feelings about the contemporaneous objection rule in general, particularly when there's a pretrial hearing on the matter. But if we have this rule, and the whole reason we have it is because we want to know if there's another judge that gets a second chance to look at everything, that's what happened here. And that happened before this subsequent evidence came in. So logically, under our jurisprudence with the contemporaneous objection rule, that's when the snapshot should be taken. We're not federal courts. Federal courts have different things. They have plain error. We don't have that in Kansas. Federal courts have different rules on this. And the way it's developed with jurisprudence in Kansas, we care deeply about the contemporaneous objection rule. Therefore, it's only logical that that's when the snapshot is taken, which was before any of this other evidence came in at trial. So hopefully that explains my position on that. Couple things to go back to touch on, just because opposing counsel mentioned, he mentioned that murder has fewer elements than other things, and therefore that somehow is relevant. The thing is, though, when we talk about lesser included offenses with murder, we're actually talking about subsection B1, because they are all lesser degrees at the same time. There's not an identity of the elements with voluntary manslaughter or these other homicides. And quite frankly, that's why we have, because I don't know of a lot of other things that are other than the batteries, where you don't have the identity elements, where you actually look at a lesser degree of the same crime. And again, the problem here, I think, is that there's different grids, not so much as the other things. And I think when you have these different grids, you're in an apples to oranges situation. So I think you're stuck with still just a strict identity elements when you're doing an analysis under subsection B2. And sorry to jump back, I forgot one last thing on the search incident to arrest. With respect to the fact of an arrest happening at all, I think there's a big danger of bootstrapping in whether or not there was going to be an arrest at all. Certainly after you find 17 grams of methamphetamine, there's going to be an arrest. But prior to that, the only crimes that there was probable cause of were open container and an improper, non-functional tag light, which is a traffic infraction. And importantly, open container is a misdemeanor. And the rules for arrest for misdemeanors are not the same as they are for felonies. And I would point the court.
Drug paraphernalia.
Excuse me?
Drug paraphernalia too, right?
That's a misdemeanor also.
Misdemeanor, right?
It's use. It's drug use paraphernalia, straw.
Right.
Sorry, I forgot about that one. But
Right.
it doesn't change the calculus because we're still talking about misdemeanors. And my point being is a notice to appear is, and there is one of the foreseeable results of a misdemeanor. And there are restrictions listed in 22-2401C. I know it's in our statute regarding the rules regarding arrests. There was no danger of him not being apprehended or a loss of evidence, and it wasn't a battery. And I'm missing one of the other exceptions.
So I don't really understand what you want us to do with that, because that's a factual question. So are you saying because they didn't argue incident to arrest at the original motion to suppress hearing? I mean, I don't, that they
that's my biggest thing is, yeah, we have, we can't look at these things later when we don't even know, we weren't.
But what do we do with that? I mean, we can't make a finding.
At that
I'm
point
sorry?
in time, it was the state's job to raise the issue at that point in time. They raised it in terms of he didn't have a privacy interest and it was or consent.
Okay, so you're saying that okay, what did I just write down? That bootstrapping about whether there was going to be an arrest at all. That's what I want to know. What do you want us to do with that?
Oh, with the fact of just whether.
So I
it's a search
understand your
incident to arrest
position,
at all.
but what do you want us to do with that?
Oh,
Because that's a factual question.
that therefore it's not, well, we know what the facts are, but that it was misdemeanors. There was no felony in play until after this search. And the fact that an arrest happened, it's, I think if you look at was it Khan, I believe, where you had two, and I think that's.
Well, her testimony was she shook it and he said it was an antacid pill or something like that.
It was, the bottle was.
The bottle was,
Yeah,
but that it sounded like, pieces of glass, that it didn't sound like, based on her, experience, it didn't sound like that. So I don't know that there's much that we can do with that. I mean, that's what she testified to. I just said that this bootstrapping thing, I don't know that there's anything we can do with it unless I guess you're arguing that because they didn't raise the incident to arrest and that you would have argued there wasn't going to be.
The arrest has to be the product. The search incident to arrest has to relate to what there was probable cause to arrest for.
Right.
That's what Khan tells us because I'm sorry if I'm butchering it. I think that was where you had, the individual had no driver's license type situation. And then the officers later searched him and found drugs. And the court.
So what
said-
did, yeah, what
And
did
there
the court
was no
do?
probable cause to go look in the car.
So they reversed
For
the,
search incident to arrest on that.
so they reversed the motion to suppress?
That one, well, but the problem was it happened in an automobile and the court said because there was probable cause for the initial offenses that were not the drug offenses, then the automobile exception applied and that cured the fact that it wasn't a search incident. It wasn't a lawful search incident to arrest. So it explained law on that and gives guidelines to a search incident to arrest, even though the evidence still was able to come in because it fell under the automobile exception. If that's clears it up, where I was going with that.
I have a question, and I think I didn't articulate it very well before, but I'm going to take another chance at it. Okay, what if we assume, for purposes of the argument here, that the first hearing, the suppression hearing, the state had a certain theory and they presented the evidence that they presented, and that's the end of it, and that wasn't enough, but they thought it was enough the first time. Then the judge says, no, I'm gonna makes a ruling. It's incorrect. But then the state says, well, wait a minute. I think I need to present some more evidence in case there's a different theory. Would the state have been able to ask for another suppression hearing before the trial?
No, there's case law on that. So there's a law of the case problem there.
You can only have one suppression hearing
One by
and you
yeah.
can't present any more evidence later on.
The case is escaping me. It was a state's appeal.
One shot, one bite. And that's it for-
Basically, you get one bite because that's exactly what the state did. The state did it. It actually even went up on appeal and they said, oh, wait, no, we're going to go back the second time around and raise this. It should have been under this. And the court said, no, you get one bite on this. The issue is the Fourth Amendment, whether it was a valid search or seizure, all or nothing is the rule on it. Kind of like, I make an analogy to a successive 1507. You get to raise the issue once, you don't get to come back and over on it.
Thank you.
Any other questions? Thank you, Mr. Dunn.
Thank you.
Thank both counsel for their arguments tonight. The court will take this appeal under advisement. You've heard me say that twice now, and to explain what I mean by that is that when the court takes an appeal under advisement after oral argument, the next step is that the court will conference both cases tonight. We will discuss them and the arguments of the council, and between us, we will decide on how we think at that point in time we believe the cases should be resolved. I will assign one of the justices to write each of the opinions. They'll draft an opinion and then that will circulate among the rest of us. We'll comment on that. We will sometimes have more discussions as we try to work through exactly how the wording should be in that decision. Sometimes we will, and often we will agree with all seven of us in that writing and how it is worded and the outcome of the decision. But sometimes one or more of us may disagree with some of the wording or the outcome, in which case we will write separate opinions. So this takes a while for us to have seven people come together in the writing of these one or more opinions. But when we do, we will issue a public statement that says that this opinion has been filed, that we will issue a short summary of our decision. And then we will also put the entire decision on our kscourts.org website. And that's true of any decision that we have. One of the things that sets a court apart, the judicial branch apart really from our executive and legislative counterparts in government, the three branches, is that courts explain their decisions. And so you can find the reasoning and the rationale for the various decisions that we reach in those opinions. You'll also, if you want to refer any of your friends or family to tonight's arguments, all of our YouTube arguments, our live streamed arguments are archived on our website as well. So you'll find both the arguments and the opinion on the websites. And so once again, I do want to thank all of you for coming tonight, and we will leave the bench and take off our robes and then join you at the reception. We look forward to seeing you there. And at this point, court is adjourned.
All right.